May it please the court. Good morning. Summary judgment should be reversed.
Can you identify yourself for the record, please?
James Thomas Smoot III for American Bible College.
Okay. Because my records here just showed that Jerry Pierce was going to show up, and I knew that that was not who was showing up here. So.
Right. He's much taller.
Yes.
And full head of hair. Please the court. Summary judgment should be reversed because it was entered without with an absolute failure to conclusively refute two affirmative defenses that were presented in the Bible College's answer, pro se, albeit pro se. They were presented. There was no motion to strike that pleading as a nullity or an amendable defect. The second reason is that there was an affidavit of Marvin Royce, the president of the American Bible College, that was not addressed in the summary judgment. It created legitimate issues of material fact. Now, the background on this, Your Honors, is that prior to 1993, there was, to say the least, some confusion about boundary lines in this little neighborhood of Pine Island, Florida, called Pineland. There had been litigation. There is attached to more than one affidavit filed by the plaintiff, a judgment that resolved a boundary issue between other parties, not the American Bible College. In an attempt to achieve conformity with that judgment, the allegations are that Colonel Randell, the father of the plaintiff, Crandon Randell, had prepared boundary agreements that were signed by some neighbors.
There was a survey done in '93 that's considered to be definitive. Is that right? A surveyor named Harris?
It's not disputed for purposes of this argument.
Which resulted in the preparation of some documents that gave ABC an additional 64 feet to the south and the southern border?
That's correct.
And then there was a document that was to have moved the northern border by 64 feet, but ABC has not entered into that portion of it. Is that
That's
accurate?
correct. And therein lies the factual issues that were not resolved. Marvin Royce's affidavit deals in great detail with that issue. Why did he not sign an agreement? First of all, he says he was never presented with such an agreement way back when, over 20 years ago.
Why isn't this case controlled? Well, the result of ABC's position is that they gain 64 feet of property.
No, they don't lose that 64 feet
well,
of property.
Their north-south property line is now extended by 64 feet over what it now becomes 247 feet instead of 183 feet.
That's
correct?
the thing is, it always was. They're trying to establish that they lose this 64.
So the 83 feet to the south was always your property even before 1993?
Yes.
So you initially had a meets and bound description that was this larger 83 feet bigger than...
It was the same size. What had happened was this litigation involving other parties back in the 80s was, it resulted in boundaries being moved down the line. Now, there was a chain reaction, so to speak, that Colonel Randell tried...
The chain stopped at your piece of property because they moved one line and not the other.
Correct.
So it's not like... So you actually did end up with 83 more feet somehow in this than what was initially purchased by your client years ago?
Yes. On balance, yes. Okay. And there's a very good reason for that, and it's the subject of Marvin Royce's affidavit. Marvin Royce's affidavit expresses that Colonel Randell had repeatedly tried to make gifts to the college, and that there was a spiritual wrestling match, if you will, between Pastor Royce, who's a very fundamental evangelical minister, and Colonel Randell, who was not quite to that persuasion. All, by the way, dealt with in detail in the affidavit. Shares of stock were gifted, were manually delivered by Colonel Randell to Marvin Royce. Marvin Royce returned those because of a spiritual determination and part of that spiritual wrestling match. There's also the statement in Marvin Royce's affidavit that Colonel Randell told him that he could keep that property. That's what we now call the disputed strip. But, and further, pulled up his fence post that had previously been used to pasture cattle. Very specific allegations of fact that were not dealt with in any way by the movant for summary judgment. Now, once again, our affirmative defenses and denials all have to do with things that occurred after the rights that they're seeking determination of would have been determined. So even if we agree for purposes of argument that through either adverse possession or acquiescence, the two being inconsistent, of course, or some other one of their other 7 theories that they pled, that they did own that property in spite of my client's deed prior to 1993, that after 1993 there was at the very least either an adverse possession or an acquiescence or agreement by Colonel Randell that the property stay with the American Bible College as it always had been with American Bible College. I'd like to just reserve 5 minutes for my rebuttal.
Okay, thank you.
If it please the court, Gordon Duncan for the appellants. We only get to the purported affirmative defenses or counterclaim if the court determines that the pleadings that were filed pro se by the corporation are viable pleadings. And we set forth in the brief the reason why they're not. A pro se corporation cannot file pleadings, and there was never an attempt by counsel to adopt those or to accept those, and so they are pleadings that are amendable. The violation can be cured, but no step was ever taken to do that.
And is this something that's automatic? Were they void documents, or was this something that someone had to object to?
The third pleading is void because it was filed without leave of court or permission of the parties, and that was under the Feltus case that we've cited. The first 2 pleadings that they filed are defective, but it appears from the Colby case that some affirmative action needs to be taken by counsel to say we either adopt them or to seek to amend them. And if you look at them, I think you understand why it's important that those be filed by an attorney, because they're basically rambling statements, and you're not sure if they're affirmative defenses or counterclaims or what relief is sought. And so it's something that is defective and can be cured, but no steps were taken to cure it. If we accept those pleadings, I think the court has seized upon what the trial court recognized, is that we had basically 2 parcels of property that for 40 years abutted one another. And there were residences built on both parcels in reliance on this location. It was later determined that these properties and others in the area were not properly mapped out, and that the true property line was 64 feet to the north. If we moved the properties up to the north, we ended up with a residence that's on the church lot being bisected by the southerly property line. So that shows that there was a mistake on behalf of the Bible College as to the location of that.
The actual true property line bisected their building, is that
correct? Right? And on the Randell parcel, there was a residence built in the disputed strip. If we move the property lines to the 64 feet north, the entire residence now sits on a parcel that is owned by the Bible College. And the Bible College admitted that.
And before the move, that property also was bisected, wasn't it? Was it partially on each property?
It was believed to be entirely on the Randell's property, but when we shift it 64 feet up, the entire residence now sits on the ABC property.
Okay.
What is actually on the ABC property? Is there a church here? I don't really know what's here.
It is a group of parcels that have what appear to be residences, single-family dwellings.
Okay.
I'm not sure of the use of those, though.
Okay.
And so when it was discovered that there was a problem with the location of the properties, Colonel Randell hired Surveyor Harris, prepared boundary agreements for his property, for the ABC property, for the property to the south of that, to make them consistent with the lines of possession.
So rather than shift north, everybody agreed to shift south.
Correct. And Mr. Harris went out and he found the old survey markers that showed where the surveyors had placed the markers in a mistaken belief and had put them 64 feet south of where they should have been. So everyone's property was the correct size. They were all just shifted down. And so it's inconsistent with their argument that Colonel Randell wanted to somehow gift this property to the church or to the college when he paid for Harris to survey these lots, these properties, create these property agreements, and the property owners below the ABC property and ABC entered into that agreement. And that established the southerly boundary of the college property. Once that happened, it's just a question of math. Their property dimension, they have a rectangular piece of property, and it's 183 feet. If we go 183 feet north from where they agreed to establish their southern boundary, we come to the location that Harris said was the line of occupation, and that puts the ABC property with the residence entirely on its parcel, and the Randell property with the residence entirely on its parcel.
So your position is in equity, they can't accept the benefit of this extended property line while not cooperating with the northern line because now they've got a windfall and they've taken an inconsistent position?
It's inconsistent, and they've adopted a position, they've agreed, and if you read the property agreement, they agree there was an error, and that by occupation, the parties had agreed to a different location. And when he agrees that there was an error to the south, it is totally inconsistent, and I think the trial court recognized that you can't come in here and now take the position, oh no, we're supposed to determine our relative positions based upon the true line of the north-south boundary. Thank you.
Okay. Mr. Smoot, any rebuttal?
Yes. First of all, I believe that the agreement signed by the Bible College just says that there was some disagreement. In the whereas portion, it says there was some disagreement about the boundary.
Why is it not an inconsistent position to take the benefit of the bargain on the southern line move, but not acquiesce to lowering the northern property boundary?
Under certain circumstances, it certainly could be an inconsistent statement, but in this case, it's not. There are so many assumptions that underlie a determination of what's consistent in equity and what's not. The agreement itself that was signed by the Bible College doesn't say anything about any other property, doesn't depend on the Bible College agreeing to anything else, number one. Number two, there are very specific reasons set forth in Marvin Royce's affidavit that he will testify to that explain why Colonel Randell did not push the issue with him. In fact,
if Randell wanted the church to have the property, then why is there a lawsuit?
Well, there wasn't for 20 years. That's the thing. This was
Up until
1993. So, but let me just address a couple of the issues about the pleadings. On the affirmative defenses set forth in the pro se pleading, under Colby reversed a trial court granting a motion to strike a pro se answer by a corporation because it didn't give an opportunity for that to be amended. Here, there was not even a motion to strike. So this, if the Supreme Court reversed the trial court in Colby, this would have to be. Secondly, even if we agree that there was absolutely no validity to the pro se answer itself, there was still an affidavit that created issues of fact that should in and of itself be a reason to deny motion for summary judgment. So I believe that's it. Thank you, Your Honor.
Okay, thank you.